Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Hello, everyone. Welcome to another episode of the Empowering Plans Podcast. I'm your host for today, Brady Bizarro, and joining me is one of our senior attorneys, Andrew Silverio. Say hello, Andrew.
Hello.
Awesome. I feel like we've all adopted this kind of intro style from Ron, for better or for worse, but I like it, so we're going to stick with it for now. But for today, we want to talk about an important Supreme Court decision that's come down. As we're recording this, I think it came down just yesterday, and it's not the one we're waiting for on Roe versus Wade. It's another one, arguably as important, maybe even more important for certain people, but having to do with dialysis carve-outs. So the court has really been rushing in the last few weeks of June to get many dozens of opinions out. I'm not sure why they're so far behind, but I think the next chance is tomorrow, or certainly last week is the last week to get some of these other cases handed down that do impact our industry, some more directly than others. But this one case, the Marietta case, has been kicked around in the court for a while. I think a lot of people actually aren't even aware that there's a dialysis case at the Supreme Court, but there had been. And it was the result of a number of lower court cases at the federal level where plan language was being challenged as to whether or not it violated the Medicare Secondary Payer Act. And finally, we have a resolution in this case in a 7-2 decision, which is, I guess, a little more notable. Even though the court does have 6 conservatives and 3 liberals, it's still noteworthy that you had a 7-2 decision written by Justice Kavanaugh. And so, Andrew, why don't you tell us about the background of this case, sort of how we got here, and from a 10,000-foot level, what it means for our clients?
Sure. We'll start from the beginning. So because of the astronomical cost of dialysis treatment in general, a lot of plans in the last years, maybe even decades, have been instituting special limitations just for dialysis to protect themselves from these costs. You know, that astronomical cost is also the reason that we have the Medicare Secondary Payer Act and ESRD, end-stage renal disease, as a basis for Medicare coverage to begin with, right? We basically have, people talk about universal healthcare, single payer system. We basically have universal healthcare just for one disease, end-stage renal disease. It's a basis all by itself for enrolling in Medicare. So plans have historically gone about this a few different ways to basically limit the amount that they pay for dialysis treatment, shift patients from the health plan onto Medicare, or both, one or the other or both. And the Medicare Secondary Payer Act is a pretty nuanced law with a lot of different requirements, but some of the broadest of those requirements relate specifically to end-stage renal disease and really aim to prevent plans from shifting liability off of themselves onto Medicare and from discriminating against people with ESRD, really to protect public funds, since we're talking about Medicare coverage. So there have been several notable cases in the last few years at the circuit level. There was a circuit split on a pretty interesting procedural issue that actually wasn't even touched on in the Supreme Court decision. But we had a decision which I was a little surprised to see, basically entirely on the merits of the discrimination question. They didn't address any of the procedural questions about, when an individual has a cause of action under the Medicare Secondary Payer Act, and lots of dry procedural stuff that wouldn't have made it for exciting headlines, but I personally think would have been a lot more interesting. But what we got is a very concise, very fact-specific holding that's easy to digest, and it's really a big win for plans and for dialysis carve-outs in general. So really what the court held was that this particular dialysis carve-out did not discriminate against individuals with ESRD and didn't differentiate between benefits it provides to ESRD patients and everyone else, really because it applies neutrally. It applies the same to all participants. Dialysis coverage is the same for everyone, regardless of whether you have ESRD or not. You have the same dialysis benefits available to you. And importantly, the court rejected, really implicitly by not really addressing it in the majority opinion, what I thought was the strongest theory challenging this language, which was the proxy theory, where basically the provider claimed that the limitation in the plan, although it wasn't a direct limitation on ESRD, was a proxy for ESRD by targeting only outpatient dialysis. Their reasoning was basically that only ESRD patients ever undergo outpatient dialysis. And there was some interesting language in the dissent taking issue with the fact that the majority didn't address this theory, looking at some parallels, a really interesting one was a limitation on wearing yarmulkes is the same thing as a limitation on Jews. So that parallel was interesting and really wasn't addressed. It was rejected by omission in the majority. They focused a lot more on just the fact that the benefits apply uniformly and didn't differentiate on their face based on ESRD, based on eligibility for Medicare.
Right. Yeah, and on that point, I mean, the court, I guess, related to proxy theory is this theory of whether there was a disparate impact, right, on individuals with ESRD, and the court rejected that theory as well. And I think it's funny when you look at some of the articles that have been written and still will be written about this case, what I have not seen, there's a lot of criticism for the health plans. They use the phrasing, a small portion was paid of whatever DaVita charged. But I haven't seen really any articles mention the fact that you have two companies that control 90% of the market here, right? So DaVita and Fresenius. So maybe one of the ways to help bring down costs for all is to allow more competition in this market, because by only having these two providers, the plan will argue, and frankly, many amicus briefs filed on behalf of the litigant in this case, including Saya itself, made this point that we've allowed some of these markets to become so monopolized and the providers have so much leverage that plans are forced to resort to these kind of cost containment strategies, being careful not to run afoul of federal law, of course, and that was affirmed in this case. But it's just kind of funny to me that that's not addressed in these articles by larger publications, that, the fact that the providers here are shown in the best light all the time. And it's kind of, frankly, a bit unfair and untrue. As we know, it's a very expensive treatment. Sure. It's a life-saving treatment. Sure. But when you only have two providers in the market providing it, they set the rates. And I think that is a lot of the reason why plans have found themselves in this situation, having to resort to these kind of strategies.
Yeah, that's a great point. And I think it was John Oliver, wasn't it, who did a pretty good look at the dialysis market and the monopoly, or the duopoly, if that's a real word, that these two provider systems controlling basically all the care that's provided in the country and all the problems that that's caused. And one of the things that the dissent said in taking issue with the opinion was basically that Congress would have to now step in, and this is some of the strongest language I've seen in one of these opinions, and fix a law that the court has broken. I thought that was a powerful line. And, hypothetically, if Congress were to step in and try to close this, I don't want to call it a loophole, but this window that plans have now to kind of impose certain types of restrictions. This isn't a blanket approval for all carve-outs. Please don't take this that way. But within these parameters, to impose these restrictions, if Congress were to step in and try to lock that down, I would really hope that they would take a look at why we have this problem in the first place and why these charges are so astronomical, and do something about that, because it impacts not just the cost of care, which is passed on to, everybody, but also the quality of care. There's a lot of issues there. When you have no real competition, prices go up, quality goes down, you have all sorts of issues.
Yeah. It's funny you mentioned John Oliver. I bet a lot of our audience and a lot of clients in our industry might not think that he'd provide anything valuable in this space to say. But frankly, if you do have a second, a good resource is to look at his show. I believe it's called Last Week Tonight with John Oliver. He does a couple segments on balanced billing, on air ambulance claims, and of course on dialysis. And I recall from watching the dialysis one that, to your point, Andrew, about quality, I think he actually sent some of his team out to some of these clinics that are providing outpatient dialysis and found just the conditions were horrendous. Like the buildings themselves, some of them had been condemned by local authorities. There's no running water or electricity. It's just, to your point, they have such a stranglehold in the market that they've really abandoned, in many cases, standards that you'd expect to apply to a facility as important as these, which are providing life-saving treatment. So I definitely encourage people to check out those kinds of resources that you may not otherwise think would provide good information, because they do. But maybe in the last couple minutes we have here as we close things out, Andrew, what do you think? You kind of mentioned this already, but what are the things that people should look out for now as to not overreact to this opinion? What are the takeaways from this case that plans need to still be aware of in this space?
Yeah, sure. So not to pat ourselves on the back too much, we can pat ourselves on the back a little bit, but really the advice that we've been giving for 10 years, it still stands. We'd want to see any limitations on dialysis imposed uniformly to all dialysis, not just ESRD patients. The limitation here applied to outpatient dialysis, which was interesting. A plan can feel better about doing that now than they could 2 days ago, as of the time of this, but I would still caution against limitations that narrow the scope even more to just ESRD patients versus others. So, tiers of coverage that kick in or cut off in a way that lines up with Medicare dates, right? Like the 30-month coordination period. If you have a plan benefit that's one amount and then after 30 months it drops down to a different amount, I would still flag that as being suspicious at the very least. But you'd probably be in a better position now than before this decision. You still absolutely don't want to single out ESRD specifically. You don't want to single out, Medicare eligibility and any benefits available to an ESRD patient, to someone who's enrolled in Medicare versus not enrolled in Medicare, eligible versus not eligible. It should be the same across the board. That's a really important element here. And I suspect we will see some folks overreacting and just kind of, seeing what they want to see and having the takeaway that anything goes now as it relates to dialysis. And that's absolutely not the case.
Right. And ultimately, if you have plan language you want reviewed, that's what we're here for. So we've done this dozens and dozens, maybe even hundreds of times, reviewing carve-out language, in particular dialysis carve-out language. So if you want to see if your language is still compliant or now is compliant in light of this decision, feel free to reach out to us at pgreferral.com and we can take a look at that language and see if we think that it's compliant with, this decision from the Supreme Court. So, all right, I think we'll have more to say on some of these other cases that are coming out any day now. So look for some more emergency podcasts from us. But for now, that's all the time we have. So I want to thank our producer, Pat the Man Santos. Thank you to Andrew, and thanks to me, I guess. And thanks to all of you out there for listening to another episode of the Empowering Plans podcast. Have a good day. Take care.